appreciate you being here today and participating in this process. I want to have just a few opening remarks before we get started. First of all, I want to make sure the parties and their attorneys understand that these arguments will be live streamed today. So this is all going out over the internet, and keep that in mind as you make your arguments. Also, I'm sure that everybody understands the process, but I want to be sure and touch base and just give you the basics before we start. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you come up and after you've introduced yourself. You may reserve up to 5 minutes of rebuttal time. Your panel today consists of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. I want to touch for just a moment on the lighting system. While you're making your argument, you'll see three lights on the podium: green, yellow, and red. As long as the light's green, you're in good shape. Once it turns yellow, you're running out of time. And once it turns red, you are out of time. So we ask that you please respect those time constraints. Anything we need to take up before we get started?
We'll switch our cases, I believe.
Okay, I think we've got a little flip-flop we're going to do here. So you may call the first case when you're ready.
Johnny Nesmith versus Samuel C. Clemmons et al.
Sir?
Should I push the lectern now or should I wait for
Yes, please, come ahead.
My name is Mark Hammervold, and I represent the appellants, Dr. Samuel Clemmons and Ms. Shannon Clemmons. I'd like to reserve 3 minutes for rebuttal.
3 minutes. All right, sir, you may proceed.
And I do want to note that I'm not listed as counsel on either of the briefs. I did file an appearance and a Rule 27D notice recently. May it please the court. This appeal involves the fundamental right to an impartial tribunal. This right is critical at both an individual and an institutional level. For individual litigants, this court has previously stated that it goes without saying that a trial before a biased or prejudiced fact finder is a denial of due process. And at the institutional level, this court has also repeatedly recognized that judges' impartiality is crucial to maintaining the public confidence and the integrity of the judiciary. And for this reason, the Supreme Court has held that the appearance of bias is as injurious to the integrity of the judicial system as actual bias. There are two overarching issues in this appeal, one substantive and one procedural.
Let me ask you a question before you get too deep in here. Can you waive that right?
Well, I would say no. The Supreme Court in Lee Medical was actually addressing the healthcare privilege for peer review, and the court noted that there's a public importance to that right, and there's a public impact to that right, and therefore the person that is meant to protect is not just the individual, but there's a system aspect as well. So I do want to say that waiver can occur in some instances, but the court should be reluctant to impose waiver given the implication for the system as a whole.
Well, why does this case rate that extraordinary analysis?
Well, this case is extraordinary because there was a Court of Appeals opinion that Your Honor signed on to in the Chase versus Stewart case.
There have been more than one Court of Appeals opinions in this case.
There have, Your Honor.
And I wrote one.
I'm aware that you've been involved at multiple levels of this case and that you were involved in one of the Chase versus Stewart opinions as well. And, what I do want to emphasize is that waiver is also tied to the specific things that were available at that time. So, for example, I think one of the issues that Your Honor might be concerned about, that all of you might be concerned about, is that there was a previous appeal of a Rule 60 motion and that appeal was abandoned. That might be the strongest point that they may make for a waiver case.
There was a previous appeal before that, wasn't there?
There was, Your Honor. Now, there was one appeal that the court considered with respect to the recusal issue, but the issues in this appeal are totally different. We're not re-emphasizing the ex parte communications or the failure to rule in 2016. This is about the series of statements that became increasingly vitriolic and increasingly direct and clear about how Judge Binkley viewed Brian Minukian, who is counsel of record in this case, and how Judge Binkley viewed Dr. Clemmons, who he viewed as working jointly with Brian Minukian and one-to-one. Now, the substance is important.
But I don't think you've answered my question yet, though. Why is this analysis, why does this require the extraordinary analysis that you say this issue can't be waived?
Well, I would point to the Chase versus Stewart opinion, both the initial opinion and the denial of rehearing, where the court said that—
Can we even look at Chase versus Stewart?
You can look at Chase versus Stewart, and the
Supreme Court said that was not for publication.
That's right. And for any of these other cases, they probably wouldn't be able to cite it, but that used to be called agree and result only, but that doesn't have precedential value. And we're not analogizing it to Chase versus Stewart as some precedent. The Chase versus Stewart opinion has independent significance because it impacts the analysis of whether a reasonable person would look at the circumstances of this case and decide that there was an appearance of impropriety.
Always been the law. It's been the law since Bean versus Bailey. It's been the law since the Supreme Court adopted Rule 10b. That's no change in the law.
And we're not arguing a change in the law. I want to emphasize the Chase versus Stewart opinion had independent significance because this court has said and made public that under these set of circumstances, Judge Binkley's continued role in the case as to Brian Minukian reasonably indicated an appearance of impropriety to an outside person.
That's a different case, though.
And it is a different case, but not only do the same set of exact circumstances appear in this case, but in footnote 5 of the decision, the court in that case specifically recognized that Judge Binkley had viewed Dr. Clemmons and Minukian as working jointly together with respect to the very facts that gave rise to an appearance of impropriety. So in Judge Binkley's mind, they're the same. So if you have two individuals to whom the same comments and the same circumstances apply, and to have inconsistent results, in one case the court said this order cannot stand because it creates an appearance of impropriety that risks the institutional legitimacy of the court, and in another case, you also can't let an order stand. Now, there's two cases that were cited in a Rule 27D notice, Ex parte Balogun and State versus Henderson. And these are out-of-state cases. But these cases are very important because they demonstrate this principle that an opinion and the results of that opinion have independent significance. Because, for example, in Ex parte Balogun, a judge had recused himself 2 prior times because he had made public statements on a political issue involving a dog racing. And a third case came up also involving dog racing, and the Supreme Court of Alabama ultimately said, where the judge did not recuse, the Supreme Court said, well, given the statements that the judge had made, that it would be improper for him to be involved in those cases due to their subject matter, that he can't then not recuse in a third case, because those comments themselves are operative to create an appearance of propriety. And here, that's the point that I want to emphasize. The Chase versus Stewart opinion itself creates the appearance of impropriety where that order was retroactively vacated, but this order is not. That order recognizes that allowing a judgment to stand after May of 2017 by Judge Binkley with respect to Brian Manukian and with respect to Dr. Clemmons creates an appearance of impropriety.
That's not what Chase versus Stewart says. It was based on the facts of that particular case.
That's right. And the facts of that particular case are intertwined with this case.
And not only was it based on the facts of that particular case, the Supreme Court said that it's not to be utilized as precedent.
That's right. And I would respectfully continue to point to the fact that the end result as to those specific circumstances, no matter how much you say Chase versus Stewart doesn't apply you can't apply this by analogy to other cases, it only is correct with respect to the narrow circumstances in that case. The same narrow circumstances exist here.
Let me ask you, when the underlying case here was tried, is there anything that we can look to in the record that would suggest that Judge Binkley held those views at the time of the trial of this case? Because as I understand it, the underlying case here was much earlier than Chase versus Stewart. So how do we know what his views were in 2014 when this case started?
Well, and this court said in Chase versus Stewart that in footnote 7, that although the hearing, one of the two hearings for contempt in that case had occurred before the comments, that the relevant time was looking at the order itself, the contempt order. And the court also said in that case that it was more probable than not that the basis for the apparent bias existed at least by May 23rd, 2017. And here, the order that we're seeking to have vacated was entered in August of 2017. So that's clearly after the time frame. Now, one other thing that I want to emphasize is not only, here I would actually make the case that retroactive recusal is even more critical than in the Chase case. You have the same circumstances in the Chase case, but you also have the Chase versus Stewart opinion itself.
Is retroactive recusal even a possibility in this state?
I would submit that it is, Your Honor, based on 3 cases. Now, I know that Chase versus Stewart, this may be getting into the point where it may not serve as a broad precedent. Now, we don't know what aspect of the...
I don't think there's any question it doesn't serve as a broad precedent. The Supreme Court has shared their thoughts on that.
Right. Well, there are some instances where the Supreme Court will deny a petition and the Supreme Court will make a comment about some particular doctrine. We don't know which aspect of the court's opinion should not be broadly precedented. But the Lilleberg opinion that is cited in the Chase case, that's still a valid precedent. That can be cited. That's a Supreme Court case. And as the court had reasoned in the Chase case, which I think the reasoning holds up, that Tennessee courts often look to the federal courts, including the Supreme Court, on recusal issues. Also, the Chase versus Stewart case did cite Olerud versus Dr. Walter M. Morgan, which is a case that is entirely appropriate for citation, and retroactive recusal was applied in that case. Now, I also too want to just address one other point. They have said one of the reasons that you cannot even consider this Chase versus Stewart case. They don't really address the merits of it, the substance of it. They're focused all on the Rule 4E, and then they also say you can't even think about it. You can't even consider the merits because of res judicata. Res judicata does not apply to this case. Because it's not a collateral case, for one. This was brought in the same case where the judgment was entered.
I don't know what you just meant by what you said.
Well, one of the arguments that the appellees make is that res judicata prevents this court from considering whether recusal should be appropriate.
And why is that inaccurate?
Well, because res judicata, first of all, only applies in a collateral proceeding, and really the applicable doctrine is the law of the case doctrine.
Res judicata, you've had the opportunity to appeal this, and you gave up your opportunity, and it became a final judgment. Why is that not res judicata? You may answer
the question. Well, res judicata, first of all, does apply in a collateral case. When you're looking at the same case, it's the law of the case doctrine.
We're looking at the very same issue here. You asked for recusal. That was denied. You attempted to, or you appealed it, and then you dismissed your appeal. That became a final judgment. Why is that not res judicata?
Well,
same parties, same issues.
Well, it's not collateral estoppel or res judicata, because the specific issue in this appeal, what's different from this appeal from the other one, is the Chase versus Stewart opinion. And we're focused on
Changing the law does not allow you another opportunity or another bite at the apple.
May I answer the
You
question?
certainly may.
Well, it is admittedly a bit of open issue of law with whether retroactive recusal should apply, but I respectfully submit that the issuance of the Chase versus Stewart opinion had an independent significance, and that the motion for retroactive recusal based on that event occurring was never considered by the appellate court, or was not even possibly raised in that appeal that was dismissed.
Thank you. You've got your 3 minutes for rebuttal.
Good morning, Your Honors.
Morning.
My name is Virginia Story. I'm from the Williamson County Bar. I had the pleasure of representing Johnny Nesmith in this matter. Johnny Nesmith and I began our relationship in 2010, so I represented him now for 12 years. He's a very fine, aging man, and I feel like sometimes in this case I've been invited to the wrong party. This started out a simple breach of contract case. 2014, we went to trial in April and May, and from the get-go, it was apparent that Samuel Clemmons and Shannon Clemmons, and I'll digress just a minute to give some context. Johnny Nesmith and Brenda Nesmith got a divorce in 2010. They owned a company named Elite Emergency Services. And what that was Johnny Nesmith had been an Alabama Highway Patrol officer, and he decided, after he retired from that career, that he would staff emergency room doctors for hospitals. So he started a company with his son-in-law, Sam Clemmons, who happened to be a doctor, and his adult daughter, Shannon Clemmons. So 2010, the divorce happens. The children are grown. They're adults. And Johnny Nesmith and his wife, Brenda, and Sam and Shannon are in business together, and they are running Elite Emergency Services. It was a wonderful business. It was at the right time. Hospitals were growing. Hospitals did not want to staff emergency room doctors. And so this was a business that ran like a top. Well, 2010, Samuel and Shannon Clemmons decided that they wanted to buy out their father and mother because they were going through a divorce, and obviously those four running the business was not going to be efficient. So they bought them out 25% for Mr. Johnny Nesmith and 25% for Brenda Nesmith, $600,000 apiece. And they paid the note to Brenda Nesmith off, paid her full amount. They paid $10,000 a month until she was paid off. And they paid their father, Johnny Nesmith, until about 2013, and they stopped paying the monthly payments. And so he reached out to them and said, hey, what's going on? I didn't get my check this month. He's living back down in Coleman, Alabama, where he's from. Oh, we're going to get it to you. We've had cash flow problems this month. We'll get it to you. It didn't happen. So Mr. Nesmith comes to see me and says, hey, can you send a letter demanding collection of the promissory note? So I write a letter. You're in breach of contract. Please pay up. Little did we know that the Clemmons were planning a lawsuit against some payroll clerks that they had been involved with in an FLSA lawsuit in federal court. And they were going to file a case in circuit court in Williamson County against these payroll clerks, and they were going to name Johnny as a defendant, Mr. Nesmith as a defendant. So this simple breach of contract enforcement lawsuit, that the note was provided and the membership transfer agreement was drafted by the Clemmons. It was clear there was liquidated damages, there was attorney's fees provision. There was really no way out of paying that money unless they fabricated some defense and started this humongous lawsuit that we ended up in. The trial of this case should have been very simple. It was 4 days in 2016, but what happened is in the middle of that trial, the Clemmons began filing Rule 10b motions to get rid of Judge Binkley. Why? I have no idea. The allegations that they made in the Rule 10 recusal motions were that Trevor Howell and Tad Harris, which were the attorneys in the federal lawsuit, met Judge Binkley at a Christmas party in Williamson County. That's all. They said, so what? You meet someone at a Williamson County bar function that's at a Christmas party, and that was reason for recusal. They didn't like that. And they didn't like some of the motions on the discovery issues that were going on. So we came up to you all, and I've been up here 5 times on this case. We came up on the Rule 10 violation, and that was denied. No, that wasn't inappropriate. There was no appearance of impropriety. Go back to trial, finish the trial. We go back again. Then the Clemmons decide that they're going to try to recuse Judge Binkley because he went to a Williamson County Bar Association boat trip function that we've had on Center Hill Lake since I was a baby lawyer in 1985. Don Young, Don Harris, all the prior attorneys in Franklin had started that tradition, and that was a simple gathering of the Bar Association, nothing inappropriate about that. And so came back up on a Rule 10, went back down to trial, finished the trial in May of 2017. So this judgment is now 5 years old. The only remand that went back down, and Judge Stafford said on that panel, it was November of 2019 when you remanded it back to Williamson County to enforce the collection of the judgment and to enforce post-judgment interest and for the judge to set attorney's fees. Judge Binkley has not touched it since then. He had recused himself in this Manukian Chase versus Stewart lawsuit that started this series of litigation that has bled over to Johnny Nesmith's case that has nothing to do with Johnny Nesmith. The parties are not the same. The attorneys are not the same. There is no privity of the parties. There is no reason whatsoever that you can cite the Chase lawsuit to use as precedent to set aside Mr. Nesmith's judgment that is 5 years old.
Mr. Manukian ever involved in this lawsuit?
He was not. He never showed up in court. He never came to court. The clerk's office found a notice of appearance that Mr. Manukian had filed in 2017. We were never served with it. He was never an attorney of record in this case. What I surmise is that Mr. Manukian's disdain for Judge Binkley, he sought out other defendants that had been ruled against that maybe have money to go against Judge Binkley. And I think that's how that common denominator happened between Manukian and Clemmons. And the only reason I would even say that is because the facts of the case that now we know, you know, if we had only known now what we should have known then, I had no idea the disdain that Clemmons had for Judge Binkley. It was not obvious in the trial. They were trying to recuse him, and I was like, well, they're just trying, they know the facts are not on their side. The breach of contract suit is factually a very sound lawsuit. And Judge Dinkins, who rendered the opinion in this case in 2019 that affirmed Judge Binkley, Judge Dinkins said, the Clemmons don't even contest the facts. The facts, there's a promissory note. Clemmons, you've got to pay up, and you've got to pay the attorney's fees for the enforcement. So, no, Manukian was not involved in my case. He never appeared in my case whatsoever. The first time I heard his name, I didn't even know about the Chase versus Stewart lawsuit. I'm not an attorney. The parties aren't privy. There's no common denominator in it. First time I heard about it was in August of 2018. We were in court on the remand from Judge Dinkins' opinion to get the attorney's fee set. A fifth attorney showed up that time, and that was Connie Regulate at that hearing for the Clemmons. Previously, they had an attorney named Brandy Lee, who was an Alabama attorney, but she didn't do her pro hoc vici correctly, and they had to recuse her from the case. And then there was Josh Wilson, and those are the two lawyers that tried the lawsuit, Brandy Lee and Josh Wilson. And then there was another attorney, and his name was Robert Blackman, and he did the appeal. And then Connie Regulate shows up in August of 2018, and that morning of that hearing, and all we were doing was a remand to set the post-judgment interest in the attorney's fees. And a newspaper article ran that very morning. Coincidence? I think not. I don't know what paper it was. It might have been a Channel 4 news story about Judge Binkley and some prior history of his. Had nothing to do with me, had nothing to do with Johnny Nesmith, didn't have anything to do with the facts of this case. A total surprise. And as a result of that, Judge Binkley's like, I'm not going to let this threat of this ugly article that appeared in the paper stop justice, basically. I'm not going to let you all hold the judicial system hostage. I think he used the term gaming the system. I'm not going to let you go to the press, get a newspaper article about me, and then come in here and game the system. At that time, he mentioned that the Brian Manukian lawsuit, that I have written an opinion where lawyers have tried to go to the press. In the Chase versus Stewart lawsuit, as I understand it, there was a protective order where the attorneys were not to talk to the press. They weren't to leak some of the facts of the case to the press. And Manukian had done that in violation, allegedly, had done that in violation of the court's protective order. And so that had become a whole thing going on where Mr. Manukian and Mr. Hammerfold was in that case. And they were sanctioned for the violations of the protective order by going to the press and providing documents in the lawsuit to the press. And so that's what started the Chase versus Stewart appeal. After that time, so we again were suspended for a period of time. Judge Binkley recuses himself from the circuit court case because he's now put together what's going on with Brian Manukian. I guess that case goes up on the appeal. It's not the final order, but they appeal at that point is that motion where they hold him in contempt and issue sanctions for his violation of the protective order. So in 2019, when we get the Court of Appeals opinion affirming the trial court, Judge Binkley recuses himself from all cases involving Clemmons or Manukian or Brian Manukian, and he sends it to Judge Parks. And so we go to Judge Parks, who sits down in our sister county of Murray County in Columbia, Tennessee. And Judge Parks sets attorney's fees on appeal, because the Court of Appeals had said it's because of the promissory note language, you have to award Johnny Nesmith his attorney's fees on appeal. He sets the attorney's fees on appeal, and he sets the post-judgment interest. And at that point, they file another Rule 10b motion, retroactive, and they file it under a Rule 60 to get Judge Binkley recused retroactively. Now, he's already recused himself. He's already off the case. He hasn't touched the case. But they accuse him that he should be recused back to 2014 when the lawsuit was filed and vacate a 5-year-old judgment. Well, the injustice that would do to the parties is very great. Mr. Nesmith is entitled to his judgment. That appeal has happened. It has been affirmed. There is no legal reason in any argument that the appellants make that can set aside that judgment. It is final. So Judge Parks, on the Rule 60 motion, he denies it. And he says, you haven't carried your burden of proof. This is not a proper Rule 60 motion. There's no reason to set aside the old judgment from 2017. Pay the balance of the judgment, pay the interest, pay your attorney's fees. Well, they don't want to do that. So they appeal that to your honors, and then they dismiss their appeal. And in that dismissal, as Judge Stafford so correctly pointed out, that is res judicata. They have already raised this exact issue once before in their first Rule 60 motion, and they dismissed their appeal voluntarily. There is nothing new that has happened since that time that they dismissed their appeal except the Chase lawsuit. That's the only thing.
I asked you one question, and that is, was res judicata raised in the trial court in response to this?
Yes, in front of Judge Parks, did we argue
Yes,
that
that's my
judge is
question.
final? Yes, sir.
Thank you.
Thank you. I'm out of time.
Yes, ma'am. Thank you. I believe you have 3 minutes.
You heard a lot about the merits of the underlying trial and the case leading up to the judgment. One reason that you didn't hear any of that in my presentation, in addition to time constraints, is because under the circumstances, the merits are not even part of the consideration. Under this court's rule, under the Tennessee Rules of Appellate Procedure 36B, there's 2 tests under which a judgment should be vacated. One is if more likely than not, it affected the judgment. So whether it's harmless error or not. And then the second is if it would result in prejudice to the judicial process. If there's an impact in the prejudice to the judicial process, you don't look to the merits. And in fact, in this court's Chase versus Stewart opinion, in the denial of rehearing, the court said that Judge Binkley's failure to recuse, quote, more probably than not resulted in prejudice to the judicial process. And also on page 2, the court also specifically said, we find it inappropriate to reach the merits. And there's no merits discussion in that case. Now, I do want to address the 2019 appeal. There was an appeal of the trial, and that reached the merits. And one of the things that you heard from the appellees was, well, this has already been affirmed on the merits have already been considered. But in that case, first of all, there was an issue about that was a matter of law. And the panel did actually determine that the defense that was presented by the Clemmonses was cognizable as a matter of law. It didn't dismiss it as a matter of law. So the issue was Judge Binkley's fact-finding. And the appellate standard of review for a fact-finding like that is a presumption of correctness. You presume the fact-finder was correct in making their decisions, in evaluating the credibility of the witness, and all kinds of things that go into the fact-finding. And that standard of appeal not only had a major effect on the prism by which the appeal evaluated the evidence, but also upon the appellant's decisions about which issues have even a chance of success. This is difficult to challenge fact finders' decisions, because they're given quite a bit of leverage, even whenever it's a judicial trial. And I do also just want to emphasize one other point. The Rule 60 motion, at the time that was made, there was no Chase versus Stewart opinion. And I want to emphasize again the utmost importance. That opinion has independent significance because it impacts how a reasonable person would evaluate whether there was an appearance of impropriety. And finally, too, their argument would allow for very bad things to occur, such as if Binkley had come out and made an even more egregious statement in 2021 under their theory.
You mean Judge Binkley?
What?
I think you called him Binkley. You mean Judge Binkley. don't
Judge Binkley, I'm so sorry. Thank you.
you? Thank you. All right, folks, we will take this matter under advisement. We will attempt to render an opinion at the earliest possible time. We appreciate your oral argument as well as your written argument. You may call the next case.